That's what I'm saying. Like, there's proof in the thing, and I just don't understand how the court is not they're not looking at the whole totality of the record.
If the landlord changed their mind at some point and said, I no longer want to accept partial payments, that's not nice, but it's not illegal.
But you're not paying attention to that. You're saying something else to cover that up.
And that is Travis Lewis versus Robert Reyes and Augustin Aguilar. Do I have someone here on behalf of Travis Lewis?
Mark Sessoms for the plaintiff.
Good afternoon, Mr. Sessoms.
How are you, Judge?
All right. Do I have anyone here? Let's do one at a time. Do I have anyone for our first defendant, Robert Reyes? Anyone for Mr. Reyes?
Am I unmuted?
I hear someone. Are you Mr. Reyes?
Okay, yeah, I'm Mr. Aguilar.
Okay, are you Mr. Reyes?
No, I'm here behind. He's in surgery right now.
Hold on, just 1 minute, sir. I'm just trying to see if the first defendant is here. Is there someone here for Robert Reyes? No. Okay. Now, is the second defendant here, Mr. Aguilar? Is that you, sir?
Yes.
Fantastic. Good afternoon. Thank you for being here.
Good afternoon.
Now, I recognize it's just you, and so technically you count for both of you, but I always like to see, sometimes what I have is defendants that don't talk anymore, so I always like to check.
No, yeah, understandable.
All right. Mr. Sessoms, please tell me, why was this case filed?
Sure, Judge. This was originally filed for possession and back rents. The tenant has since vacated the property, so we are only seeking the balance owed on rents, and that balance owed is $2,000 and fees.
Was the case originally filed for non-payment?
It was filed for non-payment and possession.
Okay. How much is the monthly rent?
Monthly rent is $1,750.
When did the defendants move out? Was it after the filing?
Oh, it was after the filing, yes.
Okay. And the $2,000 is based on what months are
that is the April rent, as well as $250 from March.
Oh, and then they moved out. Okay. So no May.
And we are seeking $700 in fees on this one.
All right. Good afternoon, Mr. Aguilar. Thank you again.
Hi, how you doing today, ma'am?
All right. So Mr. Sessoms says that there was an apartment that you and Mr. Reyes had rented, and that in that lease, the monthly rent was $1,750. So that's my first question. Is that correct? Had there been a lease in which the rent was $1,750?
Yes, ma'am. There's a lease that's $1,750, ma'am.
Okay. And then Mr. Sessoms says that you and Mr. Reyes, or you at least people have moved out. Is that true? Have you vacated the unit?
Yes, ma'am. We vacated the unit.
When did you move out?
We moved out on the. We moved out as we got the notice. We tried to pay, but then they said they weren't accepting it. So then we ended up go ahead and having to move out. So we moved out on the. We were out of there by the 30th of April.
Okay. All right. No, here recently. No worries. Okay.
Yes, ma'am.
Mr. Aguilar, is it correct that the rent for March remains? There was a balance for March and that April rent was unpaid?
Yes, Your Honor, balance exists at the time, but the evidence shows there's balances exist where a long-standing period of arrangements that the landlord repeatedly accepted and worked with us on for many months. And we do have the evidence does show.
Mr. Aguilar,
evidence does show that we do have written communication that the landlord was working with us with the rent.
All right. So, but there's no dispute that you owe it. It just hadn't been paid, and he'd been letting that slide for a while.
Yeah, no, he was accepting. We had payment arrangements.
Okay. All right.
And then
I'm only concerned if the amount of the balance outstanding, right? Mr. Sessoms says that it's $2,000, that it's $1,750 for April, and there was $250 left over from March. Is that accurate?
$250 left over for March. I believe so.
Okay. And was rent paid for April at $1,750?
Rent paid for April 17, I believe. No, he denied our payment. I'm sorry. No, ma'am. He denied the payment.
All right. All right. Well, then there's no dispute about it then. All right. Today, Mr. Aguilar, Mr. Sessoms, it would be a judgment for the plaintiff. I would award the $2,000 for rent. That's partial payment remaining from April, and then the month partial payment from March, and then the full rent for the month of April. There's no need for a possession. So, Mr. Aguilar, in earlier cases, if you listened along, you maybe have heard me talking about the writ of possession. The writ of possession is not so important in your particular situation because you've already moved out. However, though you have moved out, you still have the right to appeal this decision because there's a monetary judgment against you, right? This is an award for money. You and Mr. Reyes, if you communicate with him, you both have 5 days to appeal the judgment. Today, the amount would be $2,000 for back rent, And we would also award $750 in attorney's fees. Mr. Sessoms, is that what you sought?
Yes, Judge.
Make sure. All right. And so then for either party, I would set the appeal bond. I would make that equal to a month of rent, $1,750. That's less than the award. Also, we're no longer in a worry about possession. Okay. And Mr. Aguilar?
Okay, is there any way that could, Your Honor, I understand balances exist. My main point is that the landlord repeatedly accepted partial payments through written text communication as it states in the lease. And if he accepted over a long period of time and then suddenly changed from 1 week to the next, created severe hardship for me and my family. So, understood, Your Honor. I want the court to be aware that exhibits show, I did present exhibits and evidence. I did take it to the court showing that, and it states inside the lease that the only way that the payments can be done this way is if it's through written communication. I have a text message in my packet that I submitted. It's the 14th text message that states that he specifically states, it says, they would not fine me, not him. He said he paid the fine. I'm just cutting it to the half because it was a long message he sent me. And you have it there too. That's why it says the 14th message. And it says, I told him I do not want to get it there, but then it's in my name. He says he understands. He moved it to the stores. The city goes to the neighbors, refuse. And then it says, I just ask you work with me like we are working with the rent. I want to help you, please. I want to help you. Please help me. So there has been written communication as to the partial payments. And if you look at the papers that were submitted, everything was accepted. Everything was accepted. We have another message that was sent to him which was just sent to him on March 26th, advising him as well as like saying, everything is there in your packet that I gave, that I submitted to the court. And it shows where he's constantly giving thumbs up, never requests or never states, hey, look, we need to close this out so that we can start paying. No, he was accepting with the partial payments since I want to say for multiple years because of an issue that happened with the bank that's offset everything. And so he was accepting of it. That's what I'm saying. Like there's proof in the thing. And I just don't understand how if that's what it states inside the lease and it states that the only way that it can be changed, which we have written communication, how is it that it's just going to be ruled that way, but yet it states in the lease, that's what it states in the lease. And then also too that, like, that's what I'm saying, like the court is not, they're not looking at the whole totality of the record. And I mean, I understand that you're here for a certain thing, but I believe that I've submitted documentation and stuff that shows. And so what I'm going to be hit with is I'm going to be hit with having to pay another fine, another fee just to get this case heard. And when you're hearing the case, and I showed evidence, I showed everything that shows that this was an ongoing agreement. So that's just all I have to say for it, whatever. I just want to make that and put that on the record so that if I need to be, then we can push forward to this, because it's like saying, like, I don't believe that the court's actually taking into consideration the stuff that states on the lease that's supposed to be. And it specifically states in there that there's supposed to be written communication. There is written communication, but it's not being evaluated. And that's what I would like to know why that stuff's not being, if it states that, because it specifically states unless it was written, but that's not happening here.
Thank you, Mr. Aguilar. I can respond now. So once you have a written lease, you're correct. Statute of frauds says you can only change it if you put it in writing. If you and your landlord have casually worked out via text message and thumbs up that he let you make partial payments, that is the landlord allowing that. But it does not mean that they must continue it. In fact, your lease probably very clearly says that a waiver is not a waiver of all. If the landlord changed their mind at some point and said, I no longer want to accept partial payments, that's not nice, but it's not illegal. It's not nice. It's not illegal. It may be uncomfortable. It may be improper, but it's not illegal. If the lease says it was all do it first on the front and you have been making reasonable payments, the landlord does not have to continue to do that. That is no different than me saying, I no longer want you to pick me up late for my dates. I'm dating someone new. You have moved out. There is no dispute that you have not paid the rent for the month of April and that there was a partial payment remaining for March. Whether you ever make that payment, I don't know. I don't know that the landlord will ever pursue that payment from you. You absolutely can appeal this decision, though, and this decision is solely about money. You want to appeal, you have 5 days to do so, and you mentioned that it would cost you. But Mr. Aguilar, if you can't afford the bond, you can appeal for free. Absolutely not have to pay anything. And because you have moved out, you don't have to pay any rent to the registry because there's no worry about a writ of possession getting issued You're already out. Landlord got back their land. Now we are just dealing with money. Please contact legally about your situation,
So then,
about your
the
options in
fees,
terms of appealing.
so then the fees, whatever fees that was stated right now, those are the fees that are going to be implied. I mean, as to because it's like saying we never denied that we were going to pay him. I even messaged that, I've been trying to tell him like, hey, look, I want to pay you, but he wasn't accepting it. And so, with that being said, it says, okay, what is it that let me see, how do I say it to where, okay, it says, let me just say it like this. Okay, Your Honor, I would just respectfully ask the court to carefully consider the attorney fees being requested because the parties had an ongoing written payment arrangement for a long period of time, and communication was still being made offering dismissal if payment was completed.
Mr. Aguilar, if you had moved out before the eviction was filed, he wouldn't have gotten a dime. But because y'all moved out after the eviction was filed, state law says they get their attorney's fees, and that's a new law that went into effect January 1st. I'll get nothing for you, sir.
Okay, and yeah, because it's just like I'm saying.
Please contact legal aid about your situation because what you're saying is an empathetic situation.
I understand, but I need some things to be on the record.
We're not a court
I need
of
some
record,
things to be
sir.
on the record right quick.
Mr. Aguilar, we're
But
not
you
a
see,
court of
because that
record.
attorney came to my house and threatened me.
Mr. Aguilar.
So then what about that?
Mr. Aguilar, please contact legal aid. We are
That
done with this case.
attorney
All parties are
specifically came and
excused.
I have it on
Mr.
video and
Aguilar,
everything.
Mr. Aguilar, please contact legal aid about the things you're now rising up. In terms of the actual law here today, the law has been established. You have not denied it. Rent was not paid in full on time. The landlord gave you a notice. You had not moved out. The landlord filed the eviction and you moved out after the eviction was filed. As a result, you are responsible.
But I do know that there's certain fees that are supposed to be considered and they're not being considered. So, I mean, that's
Aguilar,
fine.
what fees would you want considered here? The only thing that's being awarded is the rent and his cost. That's per contract. That's in your statute. It's per the law. It's per your lease. If the landlord has to sue you,
and it's in contract that he states that if we have a written communication that we can do that, but you're not paying attention to that. You're saying something else to cover that up.
Mr. Aguilar, the court is now done with this. We're going to remove you. Mr. Dunn, Mr. Sessoms, all parties are excused. Thank you very much.
Judge.
All right, we're going to move to the next case.